Hi everyone, this is Emma Fitzgerald. I am today talking about a judgment that was handed down on Friday by the Queensland Court of Appeal, SDA and the Corporation of the Synod of the Diocese of Rockhampton. This particular decision concerns the disclosure obligations of respondents to historical sex abuse claims. It is likely to have some flow-on consequences for the disclosure obligations of respondents to other types of PIPA claims. So it is important to be across the principle which comes out from this matter. Now, SDA, who was the appellant, was a resident in an orphanage in Rockhampton called the St. George's Home for Children. The primary issue for determination by the Court of Appeal was whether or not the respondents were required to provide disclosure of complaints made in respect of a reverend referred to as Reverend M. And it is noted that the complaints and information relating to those complaints were received many years after the plaintiff had been a resident at the home, and also many years after the reverend in question had retired. In coming to the conclusion that it did, the Court of Appeal and Justice Fraser and Justice Morrison looked at, firstly, the meaning and purpose of the Personal Injuries Proceedings Act and the pre-proceeding framework, looking at the outlined purposes of the legislation. Then looking at the specific wording of Section 27, which is important, and I think many people working in this area of law, myself included, can at times become overfamiliar with the wording of the legislation without truly turning a critical mind to the meaning of the words. Justice Morrison looked at the specific meaning of Section 27, subsection 1b, which outlines a respondent's obligation to provide information to a claimant, if asked, that is in the respondent's possession about the circumstances of or the reasons for the incident. Now, Justice Morrison looked at how the incident is defined under the Act, and the definition is in Schedule 1 of the Act, and it says that the incident means the accident or other act, omission or circumstance alleged to have caused all or part of the personal injury. Now, keeping that in mind, Justice Morrison and Justice Fraser also looked at, well, what is the claim? What is the incident that has been alleged? And what are the particulars of negligence that have been alleged in the notice of claim? Because looking at those descriptions will identify whether or not it's an act, omission, or circumstance that is alleged to have caused all or part of the personal injury. Now, in this matter, it was alleged by SDA and their solicitors that an omission or a failure to act was causative of the personal injury which had been sustained. This was significant in leading the court to a conclusion that information in the possession of the respondent about other complaints made against Reverend M might be disclosable and fall within the requirements of subsection 1b under section 27 of the Act, which is certainly a broader interpretation than many previous matters in which I have worked. And when you look at the analysis done by the court, you can see why the court has reached that conclusion. The other important consideration is the fact that both Justice Fraser and Justice Morrison say that whether or not other complaints made are disclosable really does depend on the substance of those other complaints, and it really does require a forensic examination of, well, what information is contained within those other complaints, and does that information indicate a cause or reason for the omission which is alleged to be part of the incident. So do have a look at the judgment if you've got time. It's a really interesting reminder of the way in which statutory interpretation should be conducted. Thank you.